Arkansas Supreme Court has agreed to take on a case for paper ballot amendments. Here to talk about this case is attorney for Arkansas Voter Integrity Initiative, Clint Lancaster. Hey, Clint.
Hey, Jenny Lauren, thank you again for having me on Conduit, one of my favorite news sources, one of my favorite reporters.
Hey, you are so kind. You know that we always love having you come on here to talk. Really appreciate it. I
Well,
want
thank
you
you.
to walk us through this complaint, if you would. I know that the Supreme Court has agreed to hear it, an expedited case, but really this goes back to, well, actually, if I think about it, this goes back to the General Assembly. I know that you and your wife and a team of others worked hard regarding election integrity on several pieces of legislation. But then in November, you all worked on constitutional amendments. You sent that into the Attorney General. Those are rejected. Before we talk about the Supreme Court case, walk us through the timeline, if you would.
Sure. So then in the last regular session, the General Assembly passed two statutes. One I'm going to call Section 107, which requires Attorney General approval, and another one called Section 126E, which raised the number of counties that you have to get a signature from. So we sent our two initiatives. We have an absentee voting one and we have a paper ballot one. We sent both of those to the AG's office and said, Mr. AG, can we please be on the ballot? And he said, no, child, no. And so we ended up getting rejected. And so we then turned around and we did some editing and we sent them back. And on the second time around, on the absentee voting one, the Attorney General completely almost rewrote the thing. He rewrote it in such a way that it would have a chilling effect on a voter. And he wrote things in that weren't required. And he again rejected the paper ballot one. And so we used. Go ahead.
Well, just before you move on, for our viewers who may not be familiar, a chilling effect, what do you mean by that he wrote in?
Well, so all ballot initiatives, all ballot measures are some form or other persuasive writing. And you're trying to persuade a voter to vote for by your ballot title and your popular name. Well, the way that that's written can have an effect of like, oh, I like this, or man, this is bad. And so he took what we wanted to say, which is at its core political speech, and he changed it to quell our political speech to make the measure say what he wanted it to say. In other words, this is what the government is telling you can say to the voters at the ballot box.
Was that surprising to you whenever you all got it back?
Well, in a way, no, because he's rejected everything. So I'm not really expecting anything to change. Where I am surprised is I'm concerned, and I think a lot of people I know share this view, that Tim Griffin is not necessarily using his office to function properly in the ballot initiative process.
Yeah, I was going to ask you about that, and then we can move forward. I know that there have been a number of issues that have gone to his office. One that we've covered extensively has been the FOIA constitutional amendment issue, and that has been rejected countless times. Are you hearing, or do you feel as though the AG has politicized his office at all?
I think so, yes. And some of that's not to be expected. I mean, you're a Republican in a Republican-controlled constitutional offices and legislature. It's expected that there will be some towing of the party line. But what is not expected is that you would stomp on the constitutional rights. In our Constitution, it says that the power to have an initiative, it's a power. It says it is a power reserved to the people, and it's the first power. So it's a little bit concerning to see the Attorney General putting dousing out that fire of the first power.
So you all submitted again that proposed ballot measure in December, denied. And so where are we now?
So as I have said previously, we were not going to play this game forever.
Yeah.
And so there's a way to get to the Supreme Court using original jurisdiction in Article 5, Section 1 of the Constitution and Amendment 80, Section 2. So we have filed a complaint in original jurisdiction invoking the Supreme Court's jurisdiction over this case. And we're asking the Supreme Court to declare that our titles and popular names are legally sufficient so we can begin collecting signatures. And we're also challenging the constitutionality of 107 and 126E.
Talk to us a bit about that for our viewers who may not be familiar with that.
The 107 is where the Attorney General's approval is required. If you look at Article 5, it says that the first stop for ballot names should be the Secretary of State. The legislature can't make a statute which changes the Constitution. Okay, on 126E, previously, before the statute, you had to get signatures from 15 counties. Now they're saying you have to get them from at least 50. And what's funny about that is they're saying that, oh, that's a floor is 15 counties. The ceiling, there's no ceiling. So we're going to say the ceiling is at least 15 counties, but it's a semantics game. What they've done is they put a new floor in of at least 50 counties instead of at least 15, and they're calling that the ceiling. That's not the ceiling.
During the regular General Assembly, we mentioned this a few minutes ago, you and your group, y'all worked on several different pieces of legislation with a few legislators regarding election integrity, and you met a brick wall several times, and those who really were the biggest opposers to those pieces of legislation were fellow conservatives. I think it's to be expected for Democrats to be opposed to some of these initiatives, these pieces of legislation. But are you surprised whenever you run up against fellow conservatives who are not on the same page with you regarding election integrity?
Yeah, I am. I'm disappointed. I'm frustrated. As you know, from me being on your show before, I represented Donald Trump in 2020 in Wisconsin, the real group of lawyers. I went back and I represented the Wisconsin Special Counsel doing an investigation. And we go to a state where fraud and voting abuse is rampant. And I take the things I've learned there, and they directly inform my writing of these bills and these amendments and all the things that I do. And you would think that, having been on the front line of a battleground state where Zuckerberg pumped millions of dollars into and they openly cheated, that we would be like, hey, maybe this guy who went up there has some really good ideas about how to make elections better. But for some reason, that didn't happen. And I've got a lot of theories I could speculate on, but both my writing of the bills that I tried to run through the General Assembly this past session and these constitutional amendments are directly informed by what I saw happening in Wisconsin. And people say, well, we're not Wisconsin. Yeah, that's right. And I don't ever want to be it either.
Yeah, it seems as though anytime that you run up against opposition to this, people are like, everything's secure here. Arkansas is safe. Our elections are safe and secure. This seems to be more of a right-wing radical issue. What would you say to that?
You know, if having secure elections is a right-wing radical issue, then I would say anybody who's opposed to having the most secure elections possible is not a true person who cares about the government and freedom. Because if our elections aren't free, we're not really free. You know, there is a form of government where they let you vote, but they only count your vote if it's for the person they want. And that type of government is called communism, and it's not free. So in order for us to be free, our votes must count. We go to great lengths to make our currency secure. All right, you have special paper, holograms, all this stuff, but you can go get a ballot down at like FedEx, mark it up and send it in.
It's so scary when you think about it. You know, I was listening to Tucker Carlson recently after the Iowa caucus, and he said the Iowa caucus proves that paper ballots and voter ID work. He said that no serious country about democracy would use an electronic voting system because digital can be manipulated. And he said that we need to start demanding that we have no electronic voting machines. And I think it's really interesting that this topic, in a way, I know whenever I say mainstream, people are going to be like, Tucker Carlson's not mainstream. I'm not talking about Tucker Carlson, but I think that this issue is becoming more mainstream, that people want to see our elections secure. They don't want absentee ballots. They don't want the drop boxes. Those are not secure. We know that. So how can we move towards that?
Well, I would, you know, these petitions will be coming around in the coming months. We need everybody to sign on that we can. We need you to get out and we need you to vote. The concerns that people have, such as counting ballots, AVII recently went to Maricopa County, Arizona and filmed a hand count, and that's going to be up soon. The Rasmussen poll we ran shows that people want this. So it's not just enough to say, oh, this is good. We need you to sign the petitions. We need your help, and we would love to have that.
All right, talk to us about the timeline for this case. And then again, you want this expedited because you want this on the 2024 ballot.
Well, yeah, so we want this on the 2024 ballot. And so in our original jurisdiction complaint, I point out the role of what I call statistical decay. Okay, so for every day that passes, it's another day that I have to get more signatures than the day before. So like in December, I need like 300 a day. Okay. By May, I will need 1,100 a day. So every single day that passes, it increases the number I have to get, making that more expensive and also making it less likely that I can get them. So yes, we want it expedited because we want to be able to get the signatures in time to turn in by July. You have to have them by July. It's 90,000 signatures. And so, yes, we want, and the courts, they typically expedite these. So that's not something that's unheard of. I'm not getting,
you're not getting special treatment. Anything else that you want to add, Clint, before we let you go?
today, the FOIA group filed a complaint in the Supreme Court of their own challenging Tim Griffin's actions. So, apparently misery loves company, but I'm happy to have him.
Well, we'll be following that case as well, for sure. So a lot's happening right now.
Yes, it is.
All right. Thank you so much, Clint. We'll talk to you again soon.
Thank you.